You're watching The Court Leader's Advantage, a video podcast for court professionals and by court professionals. Brought to you by thecourtleader.net in cooperation with NACM, the National Association for Court Management. Welcome to part 2 of the Court Leader's Advantage podcast for August 2020. I'm Pete Kiefer, and this is the second of a two-part episode on the courts and systemic bias. So let's join my co-host and our panel. My co-host is Mr. Charleston Carter, Trial Court Administrator for the Superior Court in North Carolina's 26th Judicial District in Mecklenburg County. Today's panel includes the Honorable John Pacheco, Judge of the Superior Court in San Bernardino, California; Ms. Linda Romero-Soles, Retired Court Executive Officer for the Superior Court in Merced County, California; Ms. Alina Clark with the Prosecutor's Office for Genesee County, Michigan; and Ms. Elisa Chin Gary, Clerk of the Superior Court in Mecklenburg County, North Carolina. Welcome to you all. Alina, the expungement process is another area where there have been complaints of potential systemic bias. Some states, Arizona comes to mind, do not offer a process to obtain expungements. Other states have made the process very arduous. Do you think that the expungement process serves as an illustration of systemic bias? And if so, what are the solutions?
We have had expungement for a lot of years in Michigan, and it is a relatively easy process by filing a petition. There's certain offenses that are obviously excluded, but I do know, and I have to give our legislature credit here in Michigan for this, that they're currently working on legislation that will make some expungements automatic, which is even better, and it is just systematically across the board. It does not matter, it doesn't take into account any like what you look like or anything like that. It's just based on the crimes and the number of years that it will pass that it will automatically fall off. So I actually think that's a great way that Michigan is combating what is systematic racism in the judicial system in general.
I'd like to weigh in on that. I have to say, regretfully, North Carolina is one of the states that it's not that advanced as it relates to our expungement process. It is only recently that we have made an effort to make that more accessible and convenient. It has been tied up in red tape for a very long time, and it is only within the last 2 years that we have seen broader expansion. Our courts have done some public engagement in the last 2 years to ensure that people knew that it was now a new and easier process to access. So I'm glad to see that we have finally made those changes to make people more confident in our justice system, but I have to also admit it's not long-standing.
Elisa, laws prohibiting ex-felons to vote have been on the books in some states since 1792. Are these laws an example of systemic bias? And should these laws be changed?
They are absolutely an example of systemic bias. And I think that to some degree they've been in effect in every state in this country because that is our history. Our history is one of subverting the vote, sometimes by violence, sometimes by threat, and sometimes by the law. So absolutely, it is systemic bias. Should the laws be overturned? I would say absolutely. There's no question about that. Our courts are supposed to uphold a true democracy and be impartial and fair. So making that opportunity available to any member who has paid their debt to society is optimal.
Linda, what are your thoughts about voting for ex-felons?
I agree with what Elisa said. I believe the laws need to be changed and felons should be allowed to vote once they complete their prison term. California is one of 3 states, New York and Connecticut are the other 2, that requires persons convicted of felonies to complete their prison and parole sentences before regaining the right to vote. In California, if you can believe it, there are currently 48,600 individuals on parole. There's also a California ballot measure during this upcoming November election, Prop 17, that would amend a section of our state constitution if approved. It would restore the right to vote for people on parole for felony convictions.
Can I add something too, Peter? I think that if you don't see this as systematic racism, you really need to study this country's history, because the power to vote has always been used against people and kind of held above people's heads. I mean, consider the fact that you used to not be able to vote if you didn't own land. Who owned property? Women certainly couldn't own property. African Americans certainly couldn't own property. It was stolen from the indigenous people. So if you even just study what has happened, women have only been able to vote for 100 years in this country's history. So if you don't see that as another impediment or another way to perpetuate, who's in power, then I really encourage you to take a history class, because I don't know how you could look at it any other way.
Judge Pacheco, some argue that more and better training in racial sensitivity is the answer to systemic bias. Have you found that training is the most effective tool? What would make it more effective?
Well, Charleston, I want to repeat the words that you said, and that is, number one step is acknowledgement that there's a problem. Once a person acknowledges that there's a problem, then there's no doubt training and on sensitivity and on systemic bias will make you a better bench officer. Because bias, as I said earlier, has no place in a judge's ruling. It should never play a role. But with proper training, you will always be checking on yourself, saying, am I making this ruling based on some bias that I may have or some bias that I feel I may have? If you check yourself all the time, it'll help you. Unfortunately, if some of the colleagues don't understand that there's a problem, the training is not really going to help them. But I want to point this out. Our prior administration, our prior governor, I was on the Access and Fairness Committee for the state, and we were really pushing to ask that the appointment secretary please train all the judicial selection advisory committees in different counties to train them on implicit and systemic bias. It was so important that they do that. They kept saying they would, and they never did. But with our new administration and our new appointment secretary, Justice Jenkins, who's wonderful, he has made it mandatory that everybody who's going to make any vote or any decision on who's going to be our bench officers or who are good candidates, that they undergo implicit bias training. That is huge, and I think it's going to help us tremendously. Slowly but surely, our newer bench officers, they're much more open and forward thinking, which is tremendous, and I think will make us a better bench.
Alina, in your opinion, has racial sensitivity training been effective?
Well, unfortunately, we haven't had a whole lot of it yet, but I will say, to our governor's credit, she is mandating that all state employees undergo implicit bias training. She just announced that this week. And I think that that is amazing. And I hope that other states will follow, because if you don't have the people in the government that are making the laws or enforcing the laws trained on this, then it just continues to trickle down to the rest of society. And I think that it's really important that leaders be the first one to take this, because it will, it's a lot of these problems start from the top and then make their way down, and we're all dealing with the aftermath on the outside. So I can't speak to how it's worked thus far, but I am very hopeful, and I think that we're definitely on a positive uptick, that it's being acknowledged by the leaders in the state of Michigan that this is something that's necessary, and I hope that the local governments will start to follow suit.
I also think it's important, and I would venture to say this has been the experience of others, that it's also important to have the right systemic bias, implicit bias trainers and facilitators. There is the possibility of doing grave damage in an environment without professional expertise and without some real superior skills about talking and facilitating difficult discussions. In North Carolina, we've had the opportunity to have phenomenal training, and we have bore the brunt of trainers that were not so well in their performance. So I would just venture to say that that is critical in terms of being successful.
The next question for you, Elisa, is evictions are in the news, and some contend that the process is biased. Some say that the courts favor landlords. Others say that court self-help centers give too much assistance to tenants. Is there systemic bias in eviction practices? And if so, what can be done?
Well, that's a very loaded question. I would first start with the self-help centers. North Carolina, Mecklenburg County has the only, and I emphasize the only self-help center in the state of North Carolina. So that as evictions occur in 100 counties across this state, there is only one self-help center that is providing that information, and I'm very proud that it's here in this jurisdiction, and that we had the boldness of leadership to bring it here 20 years ago. In terms of landlords and tenants, I think that that is the superficial level. I think what I give attention to is really poverty. Who is the landlord and who is the tenant? And are our laws built to protect the poor or those that are property owners? Alina mentioned a moment ago that our voting rights were one time built upon who owned property. Well, our eviction and tenant laws are no different. So there is some built-in bias that would favor those that own land. The question is, through judicial decisions and through what practices we can embed in the court system to level that playing field with knowledge and information.
Linda, what are your thoughts about evictions?
Self-help centers are so important. In my prior court, the public would line up outside as early as 6:30 in the morning just to get an appointment for that day to see the attorney, and oftentimes they had to be turned away because she had already filled up to capacity, which is sad. So self-help centers are important. But back to your question on evictions, historically evictions were meant as a recourse, as we know, for landlords with tenants who were not meeting their financial obligations per their agreement. It was and still is up to the judicial officer to rule on these matters. But now, given the pandemic, millions of people lost their jobs overnight. So Congress authorized eviction moratoriums that expired at the end of July that may or may not be extended. And landlords are in a financial bind because they have mortgage payments and other bills as well. However, I read in the LA Times article just this last month that some unscrupulous landlords in South Central LA were evicting Hispanic and Black tenants despite the existing moratorium. They were locking them out of their homes, turning off their utilities and other illegal methods. But even under normal circumstances, landlords cannot evict tenants by themselves. They must go through the court process and let the judge decide.
Judge Pacheco, Department of Justice, in its analysis of courts in Ferguson, Missouri, warned that courts have become too focused on fine and fee collection. On the other hand, many courts rely heavily on user fees for their budget, particularly dealing with budget-conscious funding bodies. Could this be a form of bias, and what could be done about it?
That, to use the expression of the fellow speakers, is a loaded question. San Bernardino County, as well as the state of California, have utilized a fee waiver process, but experience shows locally that our judges are pretty liberal in granting fee waivers. And what's important is the impartiality of the judges. They should be free in their own discretion to consider a person's financial condition in assessing the fines. I think that's critical. Unfortunately, many of our fees are state mandated. However, the judge does have an ability to suspend that or to put them on a payment plan. Now, having said that, a few years back, I was doing a traffic court calendar, and many of the tickets that were coming before me on these small little trials were people that were running the intersection lights. They were running the lights, and they were caught on this camera that the city had put up. And the city had put an exorbitant amount of fines of several $100s on every violation. So they would come to me, the case would be tried, they get caught on camera, but I felt it was unfair to impose such a huge fine, and I would routinely reduce them to what the court felt was reasonable for these people. After one of the sessions, I had a city representative come to me and ask to speak to me in chambers. And I said, sure, come on back. And she said to me, Judge, you cannot reduce these fines. We rely on these fines to maintain these cameras. And I was shocked. I was literally shocked. And I said, since when am I responsible for maintaining your cameras? I have to be independent. That is what judicial independence is all about. So please leave before I report you to your superiors. That's what I do. I was just shocked. I mean, how dare that person try to say, you know what, you can't exercise your judicial discretion. Sorry, I got carried away about that.
Lena, what are your thoughts about court fines and fees?
First, I would like to say thank you, Judge. I wish that more judges were like you. And I also agree it's a loaded question, because if you look at it from a pragmatic perspective, obviously money has to come from somewhere, but how do we get it? You know, there are those that would argue that it's not fair for all law-abiding citizens to be responsible for paying to, you know, the upkeep of the court. But on the other hand, if we have a systematic racist system, the only people that are in there are unfairly there in the first place. So it's a complicated question. And I do like to see, though, in terms of the fines and cost issues, the judges that do sentencing for community service and that type of thing, I think is a very valuable tool. And I think it is a lot more rehabilitative, and it doesn't preclude somebody from getting off of probation or getting dinged on probation, a probation violation, and then being sent to jail or prison because they can't pay, or, you know, penalized for being impoverished, as we like to say sometimes in the legal community, if they can go and do something to make their community better, and then they feel more invested in it, and maybe that will help with the recidivism rate. So I do think that that is something that needs to kind of be argued more in court. If the judge isn't going to come up with it on their own volition, that the attorneys argue or suggest or stipulate even better, that would be a far better solution than just taxing people that are already in a situation. And I think that the legislature component also has to be taken into account as well. We have a situation in Michigan where we had driving while license suspended, that you would get driving while license suspended, you get court fines and costs, and then you'd have a state cost that would go to the Secretary of State. And the problem that we were having is that people could never catch up with those fees with the Secretary of State, so their license was never getting restored. So how are you supposed to go to work and take care of your business if you can't drive? And every time you do drive to go to work to try to pay your fines, you get another ticket, and worse, possibly arrested. So I definitely think it's something we need to have more discussion about reforming. I know the state of Michigan is working on reforming that and deducting a lot of those fees as it is, because it's essentially indentured servitude. I mean, I don't know how you're ever going to get out of that hole. And we as prosecutors have started using in plea negotiations, changing the charge to something like allowing an unlicensed person to drive, so you're not getting whacked with that Secretary of State fee, because you'll never get ahead.
Thanks, Elena. I like how each of you have covered some biases that's in your particular state. But I'd just like to go and ask each of you, are there any other examples that you could share with us as relates to systemic biases in your courts? We'll start with you, Elena.
I think that one thing that people need to be aware of is, just because of the way that somebody looks, that's how they identify. One of the biggest problems that I've noticed is that people just assume. So my suggestion would be to, when you're in court and on the record, to use gender neutral terms like counselor or attorney or plaintiff or defendant, or even just names. Because to assume that because I look like a woman, I necessarily identify as a woman, or vice versa. I mean, you don't know who I am or where I've been, especially if it's my first time appearing before you. But also for the defendants, if you refer to them by their names, because first of all, they're human, but secondly, you don't know what kind of problems you're going to cause them when they get in custody if you make it become a discussion with the way that they identify or things like that. So I think that trying to be as neutral as possible when you're addressing people is a really thing that we need to be more cognitive of in the judiciary.
Thank you. Linda, what about you? Are there any others systemic biases that you have recognized in your court?
Probably going along with what Alina said, I had an incident one time where I had some of the employees at the counter that were judging some of the minority customers that were coming requesting fee waivers, and they were judging them because they had designer bags. And the same thing with the bailiffs. Sometimes we would catch the bailiffs talking about minority inmates. So, I mean, we just had to, provide more training, and the same thing. Don't be judging people because you don't know what their circumstance is. I mean, is it a real designer bag? But just don't be judging people.
Thank you. Elisa?
Two things came to mind for me of areas where there's bias most prevalent that's being litigated in our courts in North Carolina right now. And one is jury selection. We still come across that quite often where there are disparities of African Americans or people of color being dismissed from juries without good cause. Secondly, I would say that there's current litigation that is winding down where there has been judicial districts drawn to advantage parties and to advantage race and change the culture and dynamics of the bench. And I think that's another way bias has shown itself. When we think of gerrymandering, we normally think of legislative districts, but it does impact judicial districts as well.
Thank you. Judge Pacheco?
Okay, so I'm going to go out on a limb a little bit here. I attended the Diversity Summit in San Diego. One of the discussions was dealing with, and I know I'm preaching to the choir here, but they were dealing with the perceived glass ceiling. And one of the complaints were people of color were not able to break that glass. And that was a big discussion. And I was surprised. Our group was huge. And we had it packed. And there were a lot of people that felt that there is this glass ceiling. And so we tried to figure out ways to how can we best handle that. And our recommendation to the people who do want to move up, because let's get real, the old days, it was a good old boy system. And you know what? We see someone that's working in the courts, they're doing a good job. And we say, let's start grooming that person to move up as a supervisor, to get into administration. That was the old rule. And so the resolve that we came to was this. If you are of color and you want to move up, you need to do everything they want you to do. You need to go to your supervisor and you need to tell your supervisor, I want to become a supervisor like you. I want to move up the system. You do everything. In other words, you make yourself available. You tell them you want to do it. So if you weren't on their plate, maybe they will put you on your plate. So that was the best resolve that we were able to come up with. And that was very interesting at that summit. That was a very interesting topic.
My thanks to Elisa, Elena, Linda, and Judge Pacheco today for sharing their thoughts on the courts and systemic bias. My thanks also to my excellent co-host, Charleston Carter. The statement by the California Supreme Court on Equality and Inclusion and the American Bar Association's Resolution 113 are both posted on the NACM podcast webpage under additional resources for this month's episode. I invite you to review both of them. Join us next month on September the 24th as we discuss diversity in the courts. And by the way, we want to hear from you. Do you have a comment about this month's episode? Do you have an instance of systemic bias that you think needs to be discussed? Email us at CLApodcast, that's all one word, at nacmnet.org. We'll try to get your comment on in a future episode. I'm Pete Kiefer, and thanks for watching. Thanks for joining us today. The Court Leader's Advantage is a regular podcast on courts and court administration. Today's episode will be available on the NACM website, on YouTube, on Facebook, and on Twitter. If you have questions, comments, or ideas for future episodes, email us. Our address is CLApodcast, that's all one word, at nacmnet.org. I'm Pete Kiefer, and on behalf of our guests, the Court Leaders website, and the National Association for Court Management, have a great day. The views, information, and opinions expressed during this episode are solely those of the host and the individual presenters. They do not necessarily reflect the position of the National Association for Court Management.